The burden of proof is a legal obligation imposed on a party at some point during the trial of a civil case. The legal obligation is to present overwhelming evidence on the issue. He is asserting in order to overcome the other party's evidence on that issue. The term burden of proof is derived from the Latin word onus probandi. The burden of proof is the obligation of a party to prove or disprove a disputed fact. Generally, the burden of proof is borne through evidence. The principle of burden of proof is related to the Latin maxim semper necessitas probandi incumbit eiqui agit, which means the necessity of proof always rests with the one who makes the accusation. In civil law cases, the burden of proof requires the plaintiff to convince a judge or jury that the plaintiff is entitled to the relief sought. This means that the plaintiff must prove each element of the claim or cause of action in order to obtain compensation. The burden of proof is the most important rule of evidence in a civil case. Generally, the plaintiff has the burden of proving by a preponderance of the evidence, or quantum meruit, that all of the facts necessary to win a judgment may be true. In a criminal trial, the prosecution has the burden of proving beyond a reasonable doubt that the defendant committed a particular crime. This is a higher burden of proof than the civil preponderance of the evidence standard. Generally speaking, there is no hard and fast standard for allocating the burden of proof in each case. The burden of proof is simply a matter of policy and equity. The plaintiff must prove each element of the claim or cause of action in order to recover damages.